morning, everyone. I would like to welcome you to this other episode of Flourish, a series of IP law webinars organized by Fenech and Fenech advocates, specifically the TMT and IP department of the firm. It's one in a series of webinars that the TMT department regularly organizes to discuss various topics and issues relating to intellectual property law. Today is a special day because it is World Intellectual Property Day, and we wanted to celebrate this day by having a good number of distinguished speakers with us to discuss specific topics relating to IP. And we decided this year, in light of the fact that the topic of the World IP Day for this year, 2022, is youth, we decided to focus on youth, on entrepreneurship, and everything that relates to how startups and young people can actually give form to their ideas, to their business ideas, through products, through services, through innovative products, and therefore flourish throughout their business careers. Today with us, we have Matthew Pisani, who is Director of Industrial Property Registrations at IPRD within the Commerce Department. We also have Elizabeth Pulo, who is Operations Manager at JAYE Malta Foundation. And we also have Mr. David Darmanin, founder of Hotjar, a very successful IT company, and we'll hear about that even later on. The format of today's webinar will be a one-to-one session. Joining me today, I have Dr. Sarah Cannataci and Dr. Deo Falzon, both lawyers working within the TMT and IP department of the firm with specializations, in fact, in IP law. So without further ado, I would like to start off the first QA session with Deo and with Elizabeth. So I'll give the floor to Deo and to Elizabeth.
Hello, everyone, and thank you for joining in. Today, obviously, I'm joined by Elizabeth Pulo, and Elizabeth, just to start things off, it would be good if you could give us some background about JAYE Malta, about specifically your targeted programs assisting startups.
Of course. So first and foremost, good morning to all the viewers and those who are joining us, and thank you very much for the invitation to be part of this webinar this morning in terms of representing youth and the development of startups from a younger age. So JAYE Malta Foundation delivers entrepreneurship programs through hands-on experiences. One of the main programs that we have that has been running for the last few years is the Startup program, which is directly also the program where we introduce concepts such as IP. The Startup program is a program targeting students between the ages of 18 to 30 at the tertiary level, primarily. The idea of it is to really encourage young people to come up with ideas for startups, and we help them through the ideation process, how to design, how to conduct research, how to plan their finances. And also one of the new topics that we've introduced is, of course, the concept of IP and protection of ideas. We find that this is something that's a very broad topic. It's quite a challenging topic, especially from a legal standpoint, which is why we think that it's also important, and we're happy to be here today to represent their voice.
And yes, in fact, and touching upon what you just said, obviously the reality is that at startup stage, if a group of people meet up, or even if it's just one particular individual behind the idea, they would be more concerned at that early stage about the business visibility, about the numbers, about the specific targeted market for the project, rather than intellectual property considerations, which is a bit more of an advanced concept. However, it is good to get a head start, obviously, on IP. And in fact, that is why we're having this kind of discussion today, because in reality with startups, we think that IP considerations should at least be on the horizon, even if in fact we know that the reality is that sometimes, other concepts take precedence. Could you perhaps shed some light into the initial issues that your participants would face?
Of course. So obviously, when starting the journey with startup, as you very well mentioned, there's a lot to be done, right? So you start off with an idea, and then you need to see initially, like, does this make business sense? Is it feasible? So obviously, there's precedence to the research, etc. When it comes to the concept of IP, this actually does, there is a bit of a light bulb, and it's not the first time. In the first few weeks, they start asking, listen, how do we protect our idea? What if we speak to companies or externals in order to get some guidance? How do we make sure that others kind of don't take up our idea just because we're looking for help? So the concern is there. Sometimes at a very, very early stage, but that's actually quite good for us because it means that, there's an interest and a yearn in taking the ideas forward. I think one of the initial, apart from a concern from their point, is understanding. IP obviously comes along with many different categories when it comes to protection of ideas. And there's many different ways on how to go about it and different things that you can gain rights for, right? So there is the concept of the idea, there's the technology, the brand, etc. So I would say that's
it's
really
interesting also, Elizabeth, that you're mentioning the concept of an idea, because at its core, I think even when startups are concerned, regardless of the eventual subject matter of the eventual project, at its core, every startup would, I think we can agree, entails an idea. And the issue, I think, at this very early stage, at the conceptual stage, even if the eventual subject matter, perhaps, if fine-tuned and fully expressed, will eventually constitute some form of registrable IP or some form of IP that is protected by law, it would be still very early for it to constitute a formal IP, which ticks all the boxes at law. So I think even though we're just mentioning an idea, it is very important, I think, especially if you have a number of contributors, that number of contributors could potentially, as you mentioned, be seeking, some external input, because they could be commissioning some form of market research, or perhaps they could be, seeking some investor involvement, and they would have to disclose some elements of their idea. So even at that early stage, when fully fledged intellectual property protection of any flavor, be it any flavor, hasn't already been, formalized, they should still keep in mind that the confidentiality of their idea needs to be protected. And this obviously can only be done at that stage through some kind of contractual arrangements between the contributors, between the consultants and themselves, even with investors. Then, we can speak about certain things such as non-disclosure agreements. Obviously, they need to be carefully drafted. But I think even at this very vague stage and at this very early start, these things should be on the horizon, at least, even if we haven't yet delved into the actual flavor of IP that best fits their actual project.
Yeah. And when talking about these things, I mean, as we're saying, there's a lot of legal background that goes into it, right? So it's even, since they're still completely new to the scene, I think it's also a bit scary, and there's a tendency to want to protect, the idea that you've come up with, because they also do this program, at least through JAYE, in teams. So there's always at least 2 people, right? They carry out this experience, at least with JAYE, as an educational experience, but some of them would actually consider, say, listen, after the next 8 months, should we consider taking this forward? So it also comes in at that point. If you were 4 people initially, just because it was a project, right? And then only 2 people want to take it forward, how do you go about this? Who actually owns the rights of the idea, because it's been developed together? So there's definitely a lot, there's a lot to it, and there's a lot of knowledge that needs to be gained, and definitely advice. So even when they come speak to us, we're not experts in this. So we always try to connect them with entities that can help them even in this remit to make sure that it's done properly. NDAs is something that we started introducing as well. So when they seek help from externals, we make sure that they're protecting their own ideas, because there's also pros and cons to these things, right? So even, for example, when gaining IP,
And I think that is why at conceptual stage, even though, as we mentioned in the beginning, IP isn't the major consideration, it is important for them at least to ascertain between themselves, especially if there's more than one contributor, who owns what, who's contributing what. At that stage, it would be a bit vague, but it would be good to think about the worst case scenario going forward.
For sure.
And I think even if we move on now, to the development stage, the actual development stage, this is where things start to get a bit more interesting, a bit less vague, and a bit more perhaps complicated and tangible. Exactly. And I know that you mentioned that when these startups and when these individuals contact you, they would be a bit, inundated with information, especially if they go on Google. Sometimes the information that would first come up would be American advice rather than European advice or even Maltese advice. And they need to understand, obviously, that intellectual property laws mainly are quite different across jurisdictions. So it's very important that when you're doing research, you're not, led astray by the US interpretations, for instance.
For sure.
And I think a startup would need to analyze, I think, at first, what is distinguishing its product or service from third parties. I think that is the first question it needs to ask, because first and foremost, it may well be a project that isn't particularly, subject to any originality per se. It was just protected at its early stages, just from a confidentiality perspective, just so that it tries to keep some exclusivity. But the product or service itself doesn't necessarily have to be something novel. But there are startups that would be involved in innovation, for instance, and this is why they need to ask themselves, what am I creating? Am I creating something completely innovative, completely novel? And does it do something completely different from the prior art?
In fact, it also comes along with knowing even where to search. As you very well said, if you go quickly on Google, you can immediately have such a massive amount of information from different countries, from different areas, different legal standpoints. And it's important, I would say, first and foremost, that you know where to go and who to speak to get the right information that applies to you. At the same time, something that we mentioned even when preparing for this is to make sure that you don't end up innocently in a situation where maybe you're designing an idea that already exists. There's an IP for, because this can also happen very, very innocently. But obviously, the law doesn't allow you, like, even if was an innocent mistake, legal structures are what they are.
Yes, so I think if we clarify our thoughts here, exactly, this is why I mentioned that we need to understand, a startup needs to understand what exactly is distinguishing its product or service. As I said, if it's something innovative, if it's something that is best suited for patent protection, for instance, yes, there is the concept that as soon as a patent, as soon as an idea that is patentable subject matter, we call it, as soon as it is disclosed, then obviously you ruin the opportunity to get a patent for it. So that is why you need to be very careful. But not all ideas are created equal, obviously, and not everything is patentable subject matter. In fact, obtaining a patent is one of the hardest forms of intellectual property rights. And it doesn't necessarily, obtaining a patent doesn't necessarily make sense for every innovation, because if you have an innovation that is very easy to reverse engineer as soon as you launch it on the market, then yes, I would say it's good to get a patent. It gives you a 20-year monopoly, subject to some extensions in some matters. And there you have that monopoly that, listen, in the jurisdiction where you obtain the patent, at least you can stop anyone and get a head start on the market, obviously, a significant head start. But then if you have another concept, which is still an invention, for instance, but it cannot be easily reverse engineered, then in that case, perhaps you shouldn't even consider disclosing the method of making it. You can just keep it as a trade secret. Obviously, maintaining a trade secret isn't something for the faint of heart, because it requires some very strict. It requires a strict, even the conduct, the way you conduct your business with your employees or with whoever you disclose the product
Internally,
or
there's
service.
more processes.
You know, exactly. It is a legal framework has been introduced, but still it entails some good, some taking care of the trade secret itself. And then, you know, it's not just about inventions, because really, I mean, most startups, and in fact, even most businesses would have a variety of intellectual property rights, because even if you have come up with a patent, you can still decide to brand it and to market it. You can still associate some content with it. And that is where the other forms of intellectual property rights come into play, because where you have the content aspect of a specific product or service, then that's something more dealt with under copyright. And incidentally, copyright doesn't require, at least in Malta, any sort of formal registration. Copyright simply starts to exist as soon as the content is expressed, is reduced to a tangible form, you know? So as soon as you get that idea and translate it and express it, then copyright starts to exist in Malta. But obviously it's only for artistic works, literary works, including computer programs, including databases, even if they're not particularly original. So there is that variety there. And then if we speak about the brand, for instance, I don't know whether the startups you deal with are particularly focused on brands.
So they do develop their own brand. It's something that we obviously introduce. We introduce it later in the day because it starts off with having the idea and finding the solution for a problem. Obviously, kind of as the startup development goes, but the brand is definitely something that they work on. Later in the day, towards the end, even prototyping. So we do kind of go into that remit, because even at the end of the program, they have to deliver presentations, and it's also a competition. So having, you know, knowing how to present the idea in a startup format with a name, with a good brand, and we take brand not just kind of as the name and the colors, but it's also the practice and the language, both written and very kind of verbal and non-verbal communication from a branding point of view of a startup.
And I think at this stage, it would be good as well to mention that both brands, for instance, and patents need to be cleared beforehand. So I know we've touched upon this, but because, you know, not everything is patentable, but even if you find something which is patentable, you need to check whether it has already been developed by someone else worldwide. So that is something which entails a significant cost, depending on the jurisdiction, and something you would need to clear beforehand. And it is the same concept with brands, because as you know, although those are, at least they are not defeated on a worldwide level, they are more like siloed off, European-wide or locally. You would still need to clear your specific brand, although, and especially if and it would be good to do early on, because if you've invested a particular sum in marketing, etc., only to find that someone else in wherever has already like marketed that specific good and service with that brand, then the rebranding process would be a bit too complicated. But that is where trademarks, for instance, come in. And also there's also the design right, which we haven't really mentioned, but it is more of a niche, subject matter, but as well, that is also important.
For sure.
I think, I don't know whether you have any concluding comments, Elizabeth, from your end.
I would say, like, in general, if there's especially any young people kind of watching this webinar, reach out, look for help, look for experts who can support in the process, because as we're saying, there's a lot of elements, a lot of bits and pieces, and it opens up, and it's such a broad topic that it's important before kind of taking any action that one seeks out the right information, because then it even ends up in waste of time, waste of energy, resources, money, etc. So that's really kind of my 2 cents. I would like to thank you very much for inviting us to speak on behalf of the young people, at least, that participate in the JAYE programs, and looking forward to seeing what the rest of the speakers have to share with us here today.
Thank you, Elizabeth. We are aligned on that, and I will leave it up to Antonio to introduce the next speaker.
Thank you, Elizabeth. Thank you, Deo. It's always interesting to see how an idea evolves to solve a problem, and then, you know, all the challenges that it brings, you know, to go to market. And I believe that sometimes we learn as we go. I don't think that, having an IP strategy is always the first thing on top of your agenda, as opposed to actually having a good product or a good service which can entice users. But again, I think the next step would be to, once you have the idea, once you have the product, once you have the service, to actually see how the law and how the various registration mechanisms can assist you to actually further protect your investment. And I think this brings us to Sarah and to Matthew, who will again be talking to us about these specific points. So Sarah, Matthew, over to you.
Thank you, Antonio. And first off, I want to say good morning to everyone. And I want to thank Mr. Matthew Pisani for joining us this morning. Just to refresh everyone's memories, Mr. Matthew Pisani is the Director of the Industrial Property Registration within the Commerce Department of Malta. And in his capacity as Director, Mr. Pisani also represents Malta in a lot of councils and committees as part of the international intellectual property authorities and organizations that exist around the world. So thank you, Matthew, for joining us this morning.
Thank you, Sarah.
First off, I wanted to just give our audience your opinion on how important it is to obtain formal protection of intellectual property, for problem-free exploitation, especially in today's digital world.
Thank you, Sarah. Good morning, everyone. Good morning, and thank you for giving me this opportunity to be with you today for this fruitful event. As you are aware, protecting your IP is a must in this digital age. It is the only legal way to avoid having your unique ideas, products or services copied or even used without permission. In a world where intangible assets have become by far the biggest assets, more than ever, IP is an essential tool for innovation, growth, competitiveness, and job creation. IP protects the fundamental knowledge-based assets, which are essential for Maltese companies, investments, and efforts to provide concrete solutions that benefit the society. I don't know if you're aware, but in 82% of all EU exports depend on intellectual property. And apart from that, infringement of intellectual property, including forced technology transfer, intellectual property theft, counterfeiting, and piracy, threaten hundreds of thousands of jobs in the EU every day. That is why an efficient and a well-designed and balanced intellectual property system are key in promoting investment, innovation, growth, and global business activities of our companies. From our end, as the Maltese IP Office, we have tried to keep abreast with the current emerging technologies, and we are firm believers in embracing, as I said, new technologies to the benefit of all our stakeholders. And basically in 2021, we promptly indicated our wish to join the EU IPO, the European Union Intellectual Property Office, in pioneering the IP register in blockchain project. With the help of the EU IPO, we developed the first blockchain technology node of the IP register in blockchain with live national trademarks data. We transferred thousands of records in real time to the TMT database using this blockchain technology. We didn't stop there. We have decided that later on also this year, we shall be the first IP office in the EU to start also issuing all IP certifications and notifications to our clients using the blockchain technology as well.
That's great. That's lovely to hear, and we're so happy to have our local IPRD within the Commerce Department that is so advanced and always working to ensure that as much as possible as well, besides allowing individuals and creators to register and protect their intellectual property, but we're doing it in such an advanced way too.
Yes, in fact, as well, I just wanted to add about this. It was a huge milestone amongst all the EU IP offices that even the president of the EU IPO, Mr. Christian Anchambault, acknowledged and commended our work we have done so far. We've also been invited last year. I have intervened in the WIPO General Assemblies where I had given an overview of the work that had been done with regards to this IP register in blockchain as well, which was a very huge achievement for us.
Of course, it's an honor. And tied to the work of the Industrial Property Registrations Directorate in Malta, besides these recent accomplishments, I also wanted to ask about the various campaigns that the IPRD has undertaken over the past years, especially in the early 2000s, vis-a-vis educating the public on the importance of IP in Malta. In your opinion, has the public's awareness today increased to a sufficient degree?
That's a very valid point, Sarah. We have done a lot, but in my opinion, this is still not enough. For example, just to give a few figures, in 2010, we received 880 trademark applications. Last year, we've increased that number to 1,580 applications, almost twice as much. We carry out annual marketing campaigns, attend seminars, conferences. We also hold additional campaigns to perhaps zoom in on particular sectors. We are currently collaborating with an esports event, which is at the moment live at the moment with the younger generation. I think people are more aware of how important it is to protect your IP. But I think from a personal point of view, I think we can increase the awareness a bit more at a national level. Another thing we've discussed internally and we're considering is to go even deeper and carry out perhaps roadshows at schools, maybe focusing on our energies on 13, 14, and 15-year-olds to go to basically the grassroots of the general public. A drawback we're facing as a directorate, as an office, is related to resources, which unfortunately are quite limited here at the Maltese IP office. Even though they're limited, we do a lot. And we're also considering, together with the EU IPO, to increase our workforce, perhaps to get deployed assistance to carry out these outreach exercises. And it's good to note as well that from a study that is being carried out at the IPO, it transpired that 96% of Europeans believe that IP is important because it supports innovation and creativity by rewarding inventors, creators, and artists. Another figure which is very encouraging is that 86% of those questioned agree that protecting IP contributes to improving the quality of products and services. These figures are very encouraging and basically motivate us to keep pushing ourselves in our long-term vision or mission to keep raising awareness among the general public and in particular to the Maltese entrepreneurs from our.
Of course, and I do think that the idea that you mentioned, going to the schools and educating the younger generation, and in line with today's theme, youth and young entrepreneurs, will not only benefit the youth themselves, but would also benefit Malta's economy, because effectively this investment would be an investment in our youth, educating them on intellectual property and the importance of IP in building a business, launching a brand, whatever it is. Because one of the things that what we can tie to what you've mentioned before as well is that IP protection combined with, for example, licensing, can also create a very wide range of strategic options to maximize that value. Because, and effectively, that's what we're talking about here today, exploiting the intellectual property that we have. And as you mentioned, it is a huge, it can be a huge part of a country's economy as well.
Correct.
And if we can use as well this part of the session to help educate our audience whilst we're at it and whilst we have you here with us, what are, in your opinion, the key steps, if any, that IP creators and proprietors should seek to undertake or should take before pursuing registration of their intellectual property, be it, whether it's a trademark, a design, a patent, all the stuff that Deo's mentioned in his discussion with Elizabeth?
I'm very happy you're asking this question, Sarah. And this is basically one of the main things we need to do to raise more awareness and make them aware, our prospective clients, on what steps they should take. As you are aware, many of us are exposed to hundreds of trademarks, patents, and designs every day. A strong and reputable IP is pivotal, basically, to our business success. This is why protecting your trademark, patents, or designs is equally important. For example, a trademark must be capable of distinguishing between the products and or services of an individual to a similar product or someone else's. I'm sure also that you are aware of how important it is to be innovative and attention-grabbing for attracting a great number of consumers to your product and or service.
And to allow those consumers to know and to get to know the origin of that product.
Exactly. On the other hand, for example, with regards to patents, this is the result, as they mentioned as well before, Dr. Falzon and Elizabeth, is the result of the creation of the human mind, which provides technical solution to an issue or a problem we are being faced with. And then if we shift to designs, a good design can create a product's reach on the market, making it more attractive to customers. This is because the aesthetic power of a design relates to many aspects of our lives and is applied to a wide variety of products. Is it enough? I don't think it's enough. So here is basically a few information on how to protect your business in today's highly competitive world. Your trademark, patent, or design needs to be easily recognized, as I said, and distinguishable from those of others. Therefore, I emphasize, and I can't stop repeating, you need to register your IP. In case for trademarks, registration gives you the unique advantage of not only having a distinctive or robust trademark, but also enjoys exclusive rights on both the name and the logo. Patents give the owner strong legal grounds to stop people from abusing of his or her invention during the protection period. And the novel design is one of the key factors that attract us to a product and in the end leads us to prefer one product to another. It therefore goes without saying that design is one of the most important aspects in selling the product, improving it and getting a return in your investment. A strong IP can open a vast range of opportunities for your businesses to grow and gain recognition even abroad. That is why you can also register for a European Union trademark, an EUTM, also known as a UTM, a registered community design, an RCD, or a European patent, an EP, basically. It all boils down, I believe, in research. Research is key. They've mentioned it before us as well. You should always carry out an extensive search on the respective area of protection, basically to see whether your logo for trademarks, the external appearance for designs, or the invention or patents already exists. This would avoid uncomfortable situations. For example, opposition procedures for trademarks or legal disputes.
Which are costly and, they take time and energy.
Correct. Very, very well said. Here at the office, we also help to go through the steps when registering your IP. We're here to basically assist at the end of the day our clients. We can either hold virtual meetings or even in person at one of the regional hubs of the service.gov, or perhaps even if they wish to do so here at the Commerce Department, and always depending on their needs as well.
Tied to what you've said in terms of searches, I think you will agree with me that as well, when it comes to ensuring that the registration that you're pursuing is problem-free as much as possible, one of the things that makes a lot of sense is ensuring or well, ensuring that your business plan, your IP strategy is already in the works prior to registration. And I think this will tie to my next question when it comes to common mistakes, that it is important for these creators to plan where they're going to be using this, whether it's going to be a trademark, a design, etc. Because one of the things that I think, and I think you will comment on this, from your experience, is that unfortunately, when people seek to register their intellectual property, they do so without having perhaps a full visibility of the plan going forward. And that would mean that they are, putting in money and time in a registration, and it will not protect them across the board, or it will not adequately protect the use of that mark or that design in the service or the good that they are planning to use it on. And ensuring that the goods and services, the classification effectively that we're looking at is correct and is relevant and that adequate is, I think, also one of the things that IP creators looking to register their IP really need to think about as well. So leading to this next question, what, in your experience, what common mistakes have you seen in the preparation and submission of applications before the IPRD, so that our audience can take note and hopefully not commit those mistakes themselves?
Very, very, very good question, Sarah. In fact, I always get use this situation which happened to a friend of mine a few years ago. Basically, couple of years ago, or even more, a friend of mine had opened a very renowned restaurant in St. Julian's. I'm not going to go into detail of the names. He had opened this restaurant, gave it a name, branding, spent tens of thousands of euros in the branding of the restaurant, and it transpired that another butcher in Malta held the name. It was registered under his name, and basically they ended up throwing down the drain tens of thousands of euros in merchandise, branding, ads, and everything like that. So that is why the research and the preparation, as even Antonio mentioned it before, that it is the strategy, the preparation when registering a trademark is imperative.
It's an investment, so you
yes,
need to
definitely
think about it.
And that is why I would like to repeat it as well once again. The office, we're here to assist. We're here to assist our clients. People or clients, prospective clients, tend to hold themselves back when contacting us, or if they want to contact us before registering their IP. Mistakes vary from format of images, the classification. That's another huge mistake that applicants carry out, that they misclassify or they classify their IP in wrong classification. Basically, even this, there is a lot of information out there on our website, on even the EU IPO or the IPO website, and I highly recommend to go have a look before submitting your applications. We receive a lot of applications which cannot be accepted as well from a legal perspective. Unfortunately, these applications tend to be non-compliant with our legislation, and that is why I repeat it. I highly suggest to get in touch with us before submitting an application for a trademark, patent, or design, or even perhaps, yes, I highly suggest that prospective applicants seek legal advice. There are very reputable IP lawyers out there, even Fenech and Fenech. Yes, we have a very good collaboration with Fenech and Fenech,
and we're very lucky to have that.
Yes, and I suggest they get in touch with IP law firms to get some legal advice, because in the long run, if they don't carry out the right checking and research, even from a legal perspective, they'll end up paying more in the long run.
And it's a waste of time, a waste of money.
That's
So
I
think the outcome of this is the biggest mistake that these creators can do is not adequately inform themselves, research, speak to whether it's the IP office, whether it's to their IP lawyers, to ensure that what they're doing and the investment that they're doing is correct and you know, they're doing it the right way. Very last question, just because I know that we're taking up Antonio and David's time. And this, I think, is one that is of value to our audience. For those of our audience who have not yet heard of it, would you explain for us in very short amount of time the ideas Powered for Business SME Fund and who can benefit from it?
Yes, very, very important. European, as you may be aware, European small and medium-sized enterprises are crucial to the European economy, since they represent over 99% of all the European enterprises and provide approximately 67% of total employment in the EU. The Ideas Powered for Business SME Fund is a grant. It's basically a grant scheme offering financial assistance designated to help EU SMEs to protect their respective IP rights. The SME Fund is a European Commission initiative implemented by the European Union Intellectual Property Office and will run again throughout this whole year in 2020. The applications can be filled by an owner, an employee, or an authorized representative of an SME acting on his or her behalf, and grants are always transferred directly to the SME following the appropriate checking made by the EU IPO. Before applying, it's very important that you make sure to have in hand the company's bank statement, containing the company's name, account holder, IBAN, BIC or SWIFT code, your company's VAT certificate or national registration certificate number, and if your SME employs the services of a representative or you are a representative acting on behalf of an SME, you must submit a declaration of power of attorney, basically, signed by an authorized owner of the SME. The SME this year, the SME Fund, given that it was very successful last year, it was increased to 75% reimbursement of trademarks and design fees at EU and national level this year as well, which has a very lovely sum. It's very good. This year as well, they've introduced a 50% reimbursement on the patent fees at national level, which is another plus in my opinion. They basically have limited the amount of grants up to 1,500 for trademarks and designs and 750 euros for patents. The OIPO have committed themselves that within 15 days of submission of the application, the SME will receive by email either the grant or the clarification or the rejection. Yes. Important, this is the last thing, and I want to close with this remark, is that before applying for a national trademark or an EU TM, a European Union trademark, they must first get the grant in hand, the grant award in hand. You cannot first apply with the office and go for the and apply. I mean, they're being very fast with this, but I think it's a very good incentive.
That's great. Yes, I agree 100%. So if any of our audience are interested in benefiting from this fund, I urge you to look into it. And I know that the IPRD website has a dedicated section to it.
And they can get in touch with us if they want, Sarah.
Exactly. We're very I strongly encourage
on this. Yes.
I strongly encourage this. Thank you so much, Matthew, for your time today. And I'll just hand over to Antonio.
Thank you. Thank you, Sarah, and thank you for giving me this opportunity once again. Thank you so much. Thank you, Antonio.
It's always so nice to be able to listen in a very simplistic and straightforward way, all the ramifications and fine-tunings when it comes to something which is abstract, exotic or esoteric as intellectual property, and the way in which an authority is there to actually guide you and help you and hold your hand in this process to make your business thrive. So definitely hats off to that, to Matthew and to your team. Now, moving on, I will put a spotlight now on David. And I always have a story to tell about David. I think it was way back in 2015 when I first met David. I think Hotjar was still in diapers back then. And I remember David trying to explain to me what this Hotjar does. In his bio, he says it's a product experience insight tool, which is now used by over 1 million websites worldwide, which is incredible. And back then, basically, I asked David, so basically, this is like Google Analytics on steroids, right? And he told me, yes, with bells and whistles attached to it. And I think the rest speaks for itself, with a fully distributed team of over 250 team members across 30 countries, a voyage which started in 2014, which is still ongoing, and which also led to the acquisition in 2021, last year in September, I believe, by Content Square. So, David, how did this all start?
Thanks for having me. I was worried when you said I have a story. So
Okay.
Now, how did it all start? It's a good question. And I really enjoyed hearing the insights that were shared before me by the other speakers as well, because a lot of it speaks to like our journey as well, right? In the beginning, we had an idea, we saw an opportunity, and we just decided to move as fast as possible. I also want to point out, I always love to say this, right? Before Hotjar, there were 2 other ideas that we had that we tried to do and they failed miserably. And I'd say probably we spent more time planning and strategy 2 times before. And it's proven that in startups, one of the most, if not the most important things is timing, right? So when you see this opportunity and you grasp it at the right time, the market conditions are right, things are in your favor, you want to move as fast as possible. So yeah, with Hotjar, it was the case that I was operating in the market. We saw that clients were unhappy with the solutions that were available. So Hotjar was not a very, I'd say, innovative technology in itself. So with Hotjar, we were kind of leveraging things that had already been invented to a certain degree. But the way we packaged them together, the elegance, the simplicity of it, and the fact that we combined different tools together and made them also very, I wouldn't say cheap, but affordable and accessible and very, very easy to use. That was, I'd say, kind of how it all started. And then immediately we saw a lot of interest, a lot of activity, a lot of demand, and we said, oh, we're onto something here. So that was the moment where we started to realize we had created something. But ultimately, we created something for ourselves.
And when did you say, okay, I'm creating something, or we're onto something here, guys? But what about intellectual property? I'm sure that wasn't the first thing you had when you were trying to solve the technical problems, but at some point you said, you know, we need to look into this from this perspective as well.
No, it's a very good question, right? So because we were moving so fast, we definitely, and that's why I said what other speakers said before me resonated a lot, right? So look, we never sat down and said, what's our IP strategy? But there were definitely key inflection points in our journey, which were kind of either, oh shit moments, right? Or aha, kind of, we should think ahead because we learned from others. So the only other thing I'd add to what other speakers said before me is speak to other entrepreneurs who have been on this journey, because there are so many traps and problems that you can get caught up in. That's a little bit of planning, right? Whether it's a trademark, which was mentioned before by Matthew, right? Or if you're innovating, creating something really new, and it's a patent, it makes so much sense to invest into in parallel, right? So, but in our case, my background is I'm actually a lawyer. So this allowed us to take a little bit of shortcuts in the beginning because there were some things that we knew about. But for us, actually, the big inflection point was, as you said, we're remote, right? So we chose to tap into the whole European when it came to product and technology. We hired across all Europe. So for us, the most important point came where we said, listen, we want to hire great people and we want to trust them. We wanted people to feel trusted from day one, but this also we were torn, right? Like we're going to hire strangers in a country that we know nothing about, and we're just going to give them our whole code base, right? So the agreement that we had to have in place, especially if they're a contractor, had to be very, very structured, well thought out and whatnot, right? So this is where we engaged Fenech to help us, because at this point I didn't have the time to spend on this. So the right partner at the right time is very, very important. Then there's obviously many other things that came down the line, but I would say it's very, very important. Outside of trademarks, which were important to us, so Hotjar had a very global outlook. So immediately identified what are the key territories we want to operate in. And to the story that Matthew mentioned before, we want to really make sure that we have a good name. We chose a very weird name because of all the other IP.
So you had actually looked before you actually went out with the name, whether this name, will cause problems?
Absolutely, absolutely. So look, back in 2014, when we launched, our outlook was global, right? So for us, this was a global offering. We knew we had to be winners in the US, we had to win in Europe. Why? Because the Hotjar engine, let's call it, of how the business operates is one that depends on volume, right? So again, we had this knowledge because we had worked before in these markets and we had operated before working for other businesses, right? So we knew this. So what we did was we spent a good amount of time researching names. So it had to be a good, catchy name, had to be short, right? That we didn't want social networks where this name has been used and registered, and obviously domain names. We didn't go far as looking at trademarks, right? Because again, like if there's no trademark, but then you have the social names and someone else is using it, it's pointless, right? So we started from more the practical point of view. And it was quite an experience. And actually the way we did it was we ultimately used premium domain listings, and we spent some money to buy a premium domain that was for sale rather than staying negotiating and whatnot. But we did a lot of checks to make sure that it wasn't kind of being used. Then once we had that in place, we moved quite quickly to make sure that there were no trademarks in place, but we didn't register. So why? Because our logic was, having failed twice, right? Our biggest...
You might be putting good money down the drain, probably.
Exactly. We knew there was a good likelihood that this would fail, right? So we said, okay, as soon as we get traction, then we'll revisit that. And I believe you guys did this for us, or I think we did some of it and then you helped us with it. But then, yeah, obviously once we were successful, then it was a global trademarking process, right? Of also registering in countries where we operate or where we're planning to operate soon. So yeah.
You mentioned something interesting where your product actually integrates or connects a lot of technologies which are already out there and make them a little bit more easy to handle. So definitely across this part, you came across quite a lot of questions when it comes to open source software, what kind of code you are replicating or transposing from other systems, how does it work with yours, whether you are overstepping the line, whether any lawyers from Redwood came knocking at your door. So what was your experience there?
We had the full spiel, right? We had lawyers knocking at our door, we had everything. But yeah, look, when you build any type of web-based software today, you're going to be using some kind of open source or library or something of the sort. So look, my advice, and we did this to a large degree, but later on we had to do it better. It's very, very important to document, even in a very simple way, what you're putting and where. Our engineers did quite a good job natively because they're obviously it's part of their culture and how they work. But it's very, very important that you're overseeing how this is recorded and where it's being used, while at the same time not holding back your engineers from experimenting and moving fast, right? You want to make this really, really simple, but just taking note of what you've done. So in our case, this was helpful for us, especially when the acquisition came in, right? When any type of M&A activity takes place, having this well documented, you're going to have to do it then
at that point. And in
so
fact,
whether it's M&A or you're going to go public or whatever, right? You're going to raise funds. You need to have this documented.
We see quite a lot of situations where successful ventures are up for acquisition, a due diligence exercise commences, and all these questions start arising. Okay, but are you touching open source software? How are your licenses regulated? So on and so forth. So actually mapping out what you have, or having a policy that as you're building, at least you're mapping out and you're keeping tabs of what actually lies inside the pot of sorts, is important. And also, I believe, ties with the fact of being agile. It's not only the fact that you can go to the market as quickly as possible because there's an opportunity in front of you, but also when it comes to M&A situations, you need to have your proverbial books in order to be able to present yourself and your company as quickly as possible. And
indeed, and one small point I will also mention, this is why I think it's important to have a legal partner up front, someone you can spar with, because especially if you're successful, someone will eventually come knocking on the door, right? So we've seen everything from IP to patents, right? Patents in the US, everything like you can imagine has been registered. So it's good to have this documented, to have a partner that understands the business, knows that you operate, because sometimes you need to move fast and you don't want to start from scratch. So in like our relationship, for example, that was very helpful for us, that you understood the business model, how we operated. That's really, really important at a certain point when these type of maybe more challenging IP discussions can come up.
But again, another important question that arises quite often is how to value your IP assets. Obviously, I'm sure this was a very heated discussion during the negotiation process for the acquisition. But in your experience, how can you put a value, a number to something which obviously is close to your heart, is something which is the fruit of your creation and the creation of your team? Did you find issues or challenges in actually finding the number to the IP assets? Because unfortunately, we find a lot of number of creatives, a lot of number of companies who are actually producing and churning IP all the time, and they end up in a situation where their IP is not even listed on their books.
Yeah. So our IP was not listed on our books.
Okay.
But there's a reason for that, right? So as I said, our innovation came more from our go-to-market strategy, how we sold it, how we packaged it. So for us, because we were leveraging a lot of existing technologies, but the way we packaged it and the experience was more important, we decided, which in hindsight was a mistake, right? So that was another opportunity that we could have thought different. I think it's very common for the maker to undervalue what they've made.
Yes.
Right? So
well, tell that to Van Gogh.
Exactly. So in our case, though, I think it was the right thing to do relatively, because ultimately, especially when the acquisition process came to be, what we found was the biggest value to them was more our brand. So it's very good that we registered the trademarks and the velocity at which we were moving and the role we played in the market versus the code base and what we had built. Because actually the company acquiring us had a product similar to ours. And actually they had invested a lot more in IP and registrations and blah, blah, blah. So it was a very interesting dynamic where they were stronger in one area, we were stronger in the other. So in a way, again, our strategy as a business, so obviously, and I don't want to give this as an example to anyone, right? Again, it's very important to emphasize that Hotjar was more about speed, packaging, low cost, distributing to the world, right? So I think wherever you're doing anything smart, anything where, not that we didn't do something smart, but when you're building something maybe more innovative, where technology plays an even bigger piece, it's important to kind of be aware of that.
And after all this experience, David, again, we had Jay. I believe someone told me you were an alumni of JAYE or Young Enterprise at some point.
I'm a huge fan of JAYE. So
if you had to give three most important hints or points, which would mirror your experience and your mistakes or your opportunities to young people. Again, we are in World IP Day dedicated to youth. you're still young, probably younger than I am. At least you have less white hair than I do. So what would be the tips you would give to up and coming people who would take up the challenge like you did and go for it?
I think my favorite tip that I like to mention quite a lot is that it's good to remember why we are in business. And unfortunately, since the 70s, the focus has shifted a lot towards profits and the shareholders. But there's, in my opinion, a much bigger theme, which is more important, especially if you want to last in business, right? To keep on going. What I like to say is much more important to think about how you're going to serve 1 million customers than how to make $1 million, right? So to me, I think if you're in it for the long haul to be successful, it's very, very important to think about the customer, right? So ultimately, who are you serving? What is the value that you're creating, right? So everything should start from there. And even when you're running the business, in my opinion, everything should be centered around that. It's not about what is our money-making strategy, right? It's how do we make customers happy strategy. Because when you have happy customers and you're delivering value, everything becomes easier, right? From making money to creating valuable IP, everything becomes easier. So it's the biggest piece of advice is there. It starts from there. The second piece of advice is the team comes first, right? So the customer is where the value sits and everything should revolve around it, but your team should come first. It's part of being a people first mindset. And if you don't treat your people, your team, with utmost respect, then they cannot treat your customers in that way, right? So everything starts with the team, but you have to protect your team, you have to trust them, you have to give them importance. And that's how you, in my opinion, create a really solid business that can achieve anything, right? Anything is possible then at that point. So I'd say those are the two tips. And the third, obviously, get your legal affairs in order, because I'll give you that last one.
Always, okay. It's always so nice to talk to you, David, for your enthusiasm and your sense of empowering people. The fact that you give them the opportunity to thrive, to grow, as long as the right parameters are set. So thank you once again for that incredible insight. And I'm sure that we'll find the right situation to speak again. On that note, I would again thank once more all the speakers, Matthew Pisani, Elizabeth Pulo, and of course David, for their thoughts and opinions that we managed to share during the last few minutes. Also, I'd like to thank Sarah and Deo from our team, and we look forward to host another webinar of Flourish in the coming weeks. So thanks everyone, and I hope you have a good day.